Hi everyone, it's Wayne Jones, the course coordinator for Introduction to Law. I'm going to give you my comments, as usual, for this week on the chapter from the textbook, as usual, The New Lawyer. And we're looking at, this week, Chapter 7, Interpretation Skills. Now, just for a bit of context and background, whatever, we're talking about, last week we talked about Chapter 6, which was the first of this section of the textbook which deals with doing. So they're saying these are the skills, the tools, the whatever, the doing part of the course. And of course, if you're thinking about pulling together any sort of problem-solving model, we're now getting into the meaty part of that model. So last week in your model, having identified problems, questions, whatever, you started to have a look at where you'd find the law, and that was not only cases, legislation, but also commentary on the law. And by now you should have had a look around the law library. Plenty of material on the site to show you how to get started. This week is more about interpretation of the law, and I find this week really quite interesting. You probably know that at some point you'll need to do a course or unit called Statutory Interpretation, and you will even get an opportunity at some stage to do advanced statutory interpretation if you wish. And look, I just find this fascinating, this stuff, because this is really the first opportunity as law students you get to see why is it that what is it that we do, lawyers, when we're looking at legislation? Do we just read the black and white letter of the legislation, whether it be the Traffic Act, the Drugs and Misuse Act, whatever the legislation is? Do we just tell our clients, well, have a look at Section 4, the answer's there, that's the end of the story? Or do we really do some interpreting? Now, I want you to take unusual approach, but I want you to take a fairly superficial look over this week's material, really for the reasons I've mentioned. That is that later on you'll do this as an entire unit, but it's very good if you come away with some major points from the chapter dealing with interpretation, and a feel for the fact that it's a series of rules, it's a series of tools that you can apply to your client's problem, or to assist your client to try and understand the law, particularly whether the law applies to them or not, whether or not they've been charged with any offence or they've been charged with breaking the law. Perhaps they just want to know, does it apply in their particular case, if they want to make sure they stay on the right side of the law. So why interpretation? Well, the ability to identify possible interpretations of legislation is what we do. That's part of our job. These rules, by the way, can apply not only to legislation, though we're talking statutory interpretation, they're just interpretation skills, interpretation rules that apply generally to things like contracts and deeds and documents and what have you. Any sort of legal text, you can try to apply these rules and make an argument with them. Okay. Before we do, the authors ask you to have a quick look at some of the characteristics of legislation. Look, I think the best thing that you can do is go online, find a piece of legislation which interests you. Now, if it were my choice, I'd be saying have a look at the Fair Work Act, for example, and just see how it's laid out. You'll see that legislation typically has sections and subsections. It might have whole divisions dealing with common areas, and then in other, it'll have parts, and just get a feel for the layout. You'll also see that some of the things I'm going to mention in a moment appear fairly uniformly at either the very front of the Act or at the very back. So, okay, the first parts of any legislation, any Act, deal with things like the number, the title, and then we'll talk about this some more in a second. Usually there's a clause somewhere at the very early part, a section, which deals with the object or the purpose of the Act. Why has this Act been made? You look for things like the date of assent, the date that the Act is meant to come into force, so its commencement date. And then either at the front or at the back in a schedule, you'll see interpretation sections and dictionaries. So they're fairly common things in a piece of legislation. The authors refer specifically to schedules to legislation as a way of keeping the Act up to date without having to change the whole Act. In that respect, think of things like, for example, Drugs Misuse Act, where new synthetic drugs are being made all the time. They're added to the schedule to the back of the legislation, so the legislation's keeping up to speed. Fish and game legislation, sometimes if a particular species of fish is becoming a little bit threatened in an area, that fish might be added to a catch limit, a bag limit section. Poisons, those sorts of things where you've got a fairly changing application for the legislation. The object of it is changing often. You'll have a schedule to it. The authors also talk about reading cases, so in that respect they've given you some hints about what you're looking for. You may have touched on this already in your reading, but if not, ratio decidendi is the actual reason for the decision that's been reached. So when you're reading a case, you're generally looking for the rule or the principle that you can quote from that particular case, which is theoretically at least binding on all other judges. But bear in mind the words the textbook authors use: the actual reason for the decision reached on the issues in dispute between the parties in that case. So not just things the judges said which sounded interesting, it has to be about that particular case. Some of you might have done an assignment with me about cheating in at university, a case called Humsey-Hancock, or one of the other cases that I've prescribed. You were looking in that particular case for the question, and that was had the person been guilty of plagiarism, and the ratio decidendi in that case, I would suggest, although it was more of a fact-finding mission, that one would be, if there was one, something along the lines, there can really only be cheating by plagiarism if there's an intention to pass off someone else's work as your own. So there's an example for you. Look, the cases are traditionally argued on the basis of different levels of generality. The textbook authors give you some good examples, but if you're really trying to create a loophole, generally you're saying that the case applies on a fairly narrow basis. If you are trying to use the case to apply in your situation, you'll often say, well, the principles in this case have a fairly broad and general application. So see what the textbook authors have to say about that. They also make you alive to the fact that apart from the ratio of the case, the most important part, there's also obiter dictum, remarks made in passing, not binding on the other judges, but usually persuasive, and a great example in the case of Hedley, Byrne and Heller and Partners, which is still used to this day, even though it wasn't part of the ratio, even though it was obiter. It went on to create a whole list of other cases about giving negligent advice. Okay, so let's talk more about interpreting the law, which is the most important part of Chapter 7. And as I said, before we get into this, you're going to do this again as a separate subject, a separate unit. So please, as long as after you've read Chapter 7, come away with some of these basic concepts, some of these ideas that the law is not black and white, that we do interpret it, we do apply a series of different rules, and I think you'll do okay. So the process. There's a figure in the textbook at 7.2, which is not a bad sort of a start. It tells you that you should think about, I guess for me what it does is it suggests that there should be some sort of an approach. They're saying, have a look at the literal approach, have a look at the context that the act is in, think about the purpose, maybe some of the common law presumptions, are there any rules that apply, come up with an answer. It's a bit high level, that version of things, but I guess the most important thing is that they're at least suggesting a process to you. So look at that figure in 7.2. The other point, I think, just in the preliminary part of the section dealing with statutory interpretation is, well, there were two things really. One was that Justice Kirby is quoted in there as saying this really is something that you need to get your head around, because there's less and less law made outright by the judges and more interpretation of legislation by judges. So this is the new business of lawyers, although new might be a little bit of a stretch, but this is really where your attentions need to be, because this is more the business of the courts these days. And courts do assist, because once they've made a finding on how a piece of legislation is meant to be interpreted, then that's it. That's the rule. Unless the legislation is changed, again, by the Parliament, that'll be the interpretation that that Act will always have for future cases. So the authors also make a point, but I don't know that they gave you an example about sometimes legislation can be drafted fairly broadly on the basis that the legislature thought, oh, well, the judges can fill in the gaps. And an example from statutory interpretation that I can give to you is that under the old trade practices legislation, now across to the Australian consumer law, was a section that just says that corporations should not in trade or commerce act in a way which is misleading and deceptive. And that's it. That's really all the legislation said. So there's a huge volume of cases around what that actually means. But what that's suggesting, and one of the first takeaways for you is that always when you're reading a piece of legislation, read it, find the section that applies, and then go straight away and see if there have been any cases on that section that interests you, because that's where your arguments will start from. That's a really important point to make. Read the Act, read the section, and then go and see if there's been any cases on interpretation, because you might be surprised at the outcome. Look, I won't go into much detail about the common law rules of interpretation. Suffice to say that they give you a bit of a background feel for how the courts have interpreted legislation over the years. It starts with the engineers case and another one called Fisher and Bell. That's the flick knife case that gets mentioned in the textbook, with the proposition that, because of the separation of powers, legislation makes the laws, courts interpret, court can't make new laws, therefore we just have to read it as it is, and if there's a mistake in the legislation, the Parliament needs to fix it up. So it's a pretty tough love approach. Then to avoid absurd situations where there's clearly some sort of a mistake, courts softened a bit and said, okay, we'll come up with the golden rule. If you read a statute, and if reading it literally absolutely leads to some absurd result, then that really can't have been the intention of Parliament. So we'll give a meaning to the legislation that doesn't have an absurd result. Great example in the textbook was Adler and George. That's the one where the person's found not in the vicinity of a prohibited place. I think it was an airbase, but I can't remember now. It was some sort of military installation. He was actually found inside, but the legislation talked about in the vicinity of. The court said, no, that would be absurd. Really, we're going to read in the vicinity of to take into account that the legislature really meant in or near, so the person was convicted. Then so that's a couple of the common law rules, but then just the text authors talk about some fairly broad approaches. This one is still very much in play, I think, the contextual approach. And what it says is when you read a piece of legislation, you don't read this word and then this word and then this word and give them all their individual meaning and then put them all back together again. That's not how we read a book. It's not how we read a newspaper. It's not how we read anything. We read it in context. So if you're reading, for example, something out of a piece of tax legislation and it's talking about income, then you look at all the other surrounding parts of the Act for the meaning of the word income or deduction or something like that. So you always consider words based on their context. There have been a number of cases. Again, you don't need to worry about this too much in introduction to law, but I'll tell you a little bit about it anyway. There have been cases that suggest context is pretty broad. It can also mean things like, well, what was the previous state of the law? What have some of the other cases been around this that the legislature and the drafters would have been taking into account? So it can mean just the words around, or it can mean a much broader historical sense of context. But the point is that many judges are now saying, no, you don't start by looking at the literal meaning of the words. You don't start with the literal meaning. You always have a look at the context. And I think the best example is probably the one I gave you. If it's a word or a phrase in a piece of tax legislation, that's the first part of the context for you. Then you look at the words immediately around it. There are a couple of great Latin maxims. If you remember them, you do. If you don't, that's okay as well. But they do come up a bit. There was Nocita Associus. That's the one about words need to be limited by the words that are around them, and the ever popular eustem generis, and that's the one that says if you've got a list of specific words and then a generality on the end, that's how you interpret the generality. An example that I can think of from time to time is if you are not allowed to take onto an aeroplane a telephone, a computer, or any other similar electronic device. What's the commonality? Is it things that can communicate with the outside world, or would that prohibit, for example, bringing on a PlayStation that didn't really communicate with others? I don't think. Electronic games, so to say electronic games. You have to look at the words that came before to interpret what the general word means. And the nocita provision, there's an example in the textbook. That's the one where they said that a prisoner needed to be taken to a police station or a prison or some convenient place. Didn't include a police car because that's pushing the boundaries a little bit too much, looking at the words that are immediately around. So I always consider the Act as a whole when you're thinking about context, but context is what we do these days. We look at the thing as part of the fabric of the law rather than just the literal meaning. But the really modern approach to interpretation is now contained in legislation. Makes sense, doesn't it? Here we're talking about legislation being the new king, very little law being made by the judges outright, lots more work of the courts is in interpretation of legislation. So the legislature itself passes some rules about how it wants its legislation to be interpreted. And I'd ask you to think about the purposive approach there. All right, well, back to this purposive approach then. What's that mean? Well, it means just like it sounds like. Every time a piece of legislation is passed, every time there's a new act, there's got to be some purpose to it. Makes sense, doesn't it? Used to be that the purpose would be found towards the front of the Act. It might be a really long-winded preamble to the Act that said something like, this is a piece of legislation which is the purpose of which is to reduce the incidence of public health issues by whatever the measure is. Now it's more likely that there'd be a section towards the front of the Act that would deal with the object or the purpose of this particular legislation. Now again, I'm not going to give you any particular examples. There may be one in the textbook, but I would rather you went off and had a look at some piece of legislation which interests you and see if you can find within the first, say, maximum of 10 sections of the Act an object or a purpose clause. And I bet you'll find one if it's a relatively new piece of legislation. This is the approach that now has legislative backing. And if you have a look at the table, I think I've got this right, 7.1. No, if you have a look at the table in the textbook, which deals with what legislation is out there in the world today, it will tell you what. Here we go. It's it's table 7.1. Have a look at table 7.1 on page 258 of the first edition of the text. It tells you there's, for the Commonwealth, there's the Acts Interpretation Act of 1901. Now, obviously, that's been changed a lot since then. Queensland, again, Acts Interpretation Act 1954. So there's one for each state. There's one for each of the territories. Have a look at that piece of legislation and just have a bit of a scan through and maybe apply some of those rules I was mentioning before. That is, what's the early part of the Act about, etc. Anyway, that's the modern approach, is to put it into a piece of legislation. Now, for our purposes, for introduction to law, just two sections to have a look at, although I'm going to mention some others. But 15AA in the Commonwealth Act, for example, says, in interpreting a provision of an Act, the interpretation that would best achieve the purpose or the object underlying the Act, whether or not it's stated in the Act, is the one to be preferred to each other interpretation. Now, of course, that gives you lots to work with, because it's presuming that sometimes the Act mightn't say what its object or purpose is. But nevertheless, that's your task. If you're trying to interpret the Act, you've got to work out first and foremost what the object and purpose is. Still got to be consistent with the words that are in front of you, but it gives you a bit more latitude. Where do you look for the object and purpose? And this brings me to the second section I'd like you to have a look at. Have a look at section 15AB, 15AB in the Commonwealth legislation. And it gives you a whole list of things that you can look at if you're trying to work out the meaning of Commonwealth legislation. And the two that are probably the most important that come up time and time again, and you do see referred to in cases, are the explanatory memorandum. So when a new piece of legislation is put up to the Parliament, there's usually an explanatory memo that tells the rest of the Parliament what the Act is about. And there might also be a speech from the Minister who's introducing the legislation. So they're two really important pieces of extrinsic material that you can look at to try and work out the object or the purpose of the Act if the Act itself doesn't tell you what that is. There are also some good examples given in the textbook about how that can be applied. There's also in the interpretation legislation, by the way, some statutory rules, and if you have a look at Part 8, for example, you'll see that. So not only does the interpretation legislation say in a general way how you should approach the task, that is, think about the object and the purpose. Yes, by all means, go and look at extrinsic material if it helps you to find the object and the purpose. But it also has some of those little terms and conditions you often see in the front of leases and contracts and deeds, where instead of having to repeat yourself all the time, they set up some rules at the beginning. You know, they might say, for example, words referring to one gender in this contract really refer to all genders. That sort of thing, distance and time and what have you. So in Part 8, it has some really specific provisions dealing with measurement of distance, calculating time, expressing time, attaining a particular age, and they apply to all Commonwealth laws, so that a new piece of Commonwealth legislation doesn't need to have that section in it. It doesn't need to have a section that says, well, when you're calculating time, you start at midnight and then you go through till 1 minute to midnight the following day, or whatever, because it's in the Commonwealth interpretations legislation. You only see a reference if the new Act wants to do something different. But in the absence of that, you just apply these rules. Really important. You'll see them again in statutory interpretation as a unit when we talk about time limits. So do have a look if you get a chance at section 36. Look, there's a reference also to some interesting common law presumptions, but I'm just going to limit you to a couple of them that interest me. I'd say have a look at these. First one is that words have their common meaning, their current meaning. Great little example given in there that suggests to you that the statute is always speaking. And I think the example off the top of my head was something like referred to a list of things like telephones and the like in a piece of legislation that was made before TV even existed, and the courts will interpret that to mean, you know, whatever the current state of technology is, within limits. So that we say the statute's always speaking. It refers to some sort of transportation device, and the Act was made in 1920. Well, it obviously refers to more than just a horse and cart. You can apply it to a car. Provisions aren't usually retrospective, so new laws don't usually apply backwards unless they're really quite specific. Penalty provisions normally construed in favour of the citizen. So in other words, in working out the interpretation of a piece of legislation, the judges are normally tougher on the state than they are on the individual that's fronting the court. Things not included are automatically excluded, and specific provisions override general provisions. And have a look at the examples in the textbook for those. One might be, the last one, for example, specific provisions override. If somewhere in an Act about using the public transport system in Brisbane it says no animals are allowed on the train, right? That's the general. If there's then a specific section in that piece of legislation or another that says that guide dogs are to be allowed onto any form of public transport, because it's been quite specific, it overrides that more general one that just says, so you can't usually bring animals on the train. So have a look at the examples for those two. Final thing I wanted to say to you was, I'm not going to go into, and I don't really want you necessarily, read on from that point if you wish. Have a look at the comments about just generally interpreting contracts and documents, but just two things from my point of view at this very early stage. One is, when you're interpreting a contract, it's always read objectively. That means the words have to speak for themselves. It's no good saying, oh, when I wrote that section in the contract that said, and I think the example in the text was, I'm selling the house and all the contents of the shed, I actually didn't mean my wheelbarrow. Honestly, your intention doesn't matter. It's what's black and white there. The contract has to speak for itself. So we say that contracts are interpreted from an objective perspective. In other words, what would anybody else reading the contract see or think when they read it? The parole evidence rule was the only other point I wanted to raise with you out of Part 7, and that's the rule that says, you know what, if it's in writing and it's in the contract, that's the end of the story. No good telling me about what other collateral agreements you say you had. If it's in there, it's presumed that the contract contains all of the terms and conditions that it needs to operate. And there has to be some certainty in business and doing business. Now, like always, there's exceptions to that rule, but that's really for a contract course and not for today. The first rule of interpreting a contract is that it's objective. The second is, if it's in there, don't tell me about anything, other discussions that were held outside. The contract should stand on its own two legs. That's all I wanted to say to you about 7. Bear in mind that you will be dealing with this in a much more detailed way in due course. So just come away with some of those high level, much more fundamental things. One is black and white just ain't always black and white. Secondly, there are a series of rules which you can apply to try and work out what the legislation means. And thirdly, that the one that sits at the top of the heap at the moment is probably the object and purpose rule. But a close second is you're always looking at the context for the legislation, and context can include even things like what the minister had to say about the Act when it was being introduced. So that there are rules. One of the students has already written to me to say, oh, is it this whole section seems to be about loopholes. I guess you could put it that way. It's a bit negative, but it's more to the point that you are entitled to argue any reasonable meaning for the legislation, unless that particular section has already been dealt with by a court, has been examined, and the court's come up with a meaning for the section that you say is contentious. But if your client has slightly different facts and their facts don't quite fit with, or they don't seem to be addressed by the legislation, that's when you'll really earn your fees. Okay, good talking to you, and I hope you enjoyed. We'll talk again soon about the next chapter in the doing section of the textbook, and that's thinking skills.